Thank you for joining the New Mexico Department of Workforce Solutions Employer Webinar Series. Today's topic is Understanding Unemployment Insurance Tax, 6 Tips to Achieve a Lower Unemployment Insurance Tax Rate. Please submit your questions using the Q&A at the bottom of your screen. You can also send us a chat if you'd like. This webinar is being recorded and it will be on the New Mexico Department of Workforce Solutions YouTube channel, and I will put that in the chat for you so you can see where that's at. And right now, it's my pleasure to introduce our speakers for the day, our Unemployment Insurance Claims Administrations Manager, Steve Madigan, and the Adjudication Supervisor, Charles Garcia.
Hi, everyone. Thank you so much for joining us today. As Stacy said, what we're going to be looking at are some tips that we can offer to help you to lower your unemployment insurance tax rate. But before we get started with that, I just want to give you a little bit of a background about the unemployment insurance program. The unemployment insurance program was passed as part of the Social Security legislation back in 1935. And it was meant to give temporary wage replacement to people who are out of work due to no fault of their own. So it had its origins in the Great Depression, and obviously it's something that has survived and evolved since then. It is operated by both the federal and the state government. The state, or the federal government rather, provides the states with broad guidelines, which we then must follow in implementing our individual state laws regarding the unemployment insurance program. And then, of course, we are audited by the federal government as well. So unemployment insurance benefits are paid for out of a trust fund that are supported exclusively by employers. And that arrangement is set up in New Mexico state law. So what our job here at the New Mexico Department of Workforce Solutions is to administer New Mexico's state unemployment insurance program. So what the unemployment insurance division does, which both Charles and I are a part of, is we pay unemployment insurance benefits to eligible claimants, and we also collect unemployment insurance taxes from liable employers. And again, the unemployment insurance tax is the focus of what we're going to be discussing this afternoon. So as far as achieving a lower unemployment insurance tax rate, and if I slip into the acronym UI, that's what it is, unemployment insurance. So these first three items, reporting and paying contributions promptly, reporting fraud, and reporting individuals who refuse offers of work, are relatively straightforward. I will go through them briefly, but then we're going to spend more time on the last three, which is responding effectively to unemployment insurance claims, implementing clear employee policies and keeping records, and then finally understanding eligibility requirements. And those three are intertwined, so they're not going to be presented as separate elements, but we'll talk about those three subjects as one when we get to it. All right. The first one, reporting and paying contributions promptly. So this one is a relatively simple concept. The key here is to avoid penalties and interest. So if you're not registered with the agency when you should be, when certain thresholds are met regarding wages paid in a quarter, the number of employees you have, etc., there is a penalty associated with that. If the quarterly wage reports are not submitted timely, or if payment is not submitted timely, there is a penalty for that. And then there's interest on any of the taxes or contributions that might be late. So with this one, plain and simple, as long as you are timely in reporting and paying, then this wouldn't be a problem for you. The next one, reporting fraud. Fraud depletes the UI trust fund. So a fraudulent claim, and we'll talk about two different types of them in the next two bullet points, are benefits that are paid out. And then obviously once fraud is determined, we try to collect it back. In a lot of instances, we're unsuccessful in doing so. So it is a drain on the money that's there to use to pay benefits. And how that impacts you as far as your unemployment insurance tax rate in the calculation, and I'm not going to get into the math, there is a reserve factor that's intended to preserve or uphold the health of the trust fund. So obviously, as the trust fund is drawn down, the lower the balance it is, the higher the reserve factor, which then impacts your individual employer tax rate. So that's how this impacts what you're actually paying. So on a weekly basis, we run cross matches with the national and state new hire directories to see if there is anyone who's been hired, so is now working and still has an active claim. So how you can help us out on this, and again, to preserve the health of the trust fund, is by reporting new hires as you hire them to both of these directories. That allows us, when we run the cross matches, to catch those individuals who might be claiming benefits, so saying they're unemployed, who've actually returned back to work. And then the final bullet point here, reporting any employees who are still employed but have filed for unemployment insurance. And that was something we actually saw quite a bit of during the pandemic. So there are instances of identity theft. The person who they're using their name and social security number are typically unaware of it. However, because the fraudster is using a bogus address, a bogus phone number, so there is no contact with the actual individual. But with the claim, we're still reporting to you, the employer, that a claim has been filed. So if you see that a claim has been filed under an employee's name who is still working there, by all means, let us know. Don't simply disregard it, assume it was a mistake. It's possibly identity theft. Next one, so reporting individuals who refuse offers of work. And we do get quite a bit of feedback on this and have for the past several years at least. And then as a result of that, we did create a button or a link within your employer account that I believe it's entitled report, or no, it's refusal of suitable work is what it says. And I'll explain what suitable is. That's something that's more on us and not on you. So a claimant who receives benefits, one of the eligibility requirements is that they actively seek work. So they have to be able to work, available for work, and actively seeking work. And what New Mexico law requires is that they make a minimum of 2 job contacts per week. So ideally 2 applications per week. Obviously, if they interview and get a job, that's the goal. So we want them to be able to become reemployed, get off of unemployment benefits. They're back to work, back to their normal lives, hopefully. When the individual does their weekly certification, so each week they're certifying that they continue to meet the eligibility requirements of the program, one of the questions is if they were offered work, and then if they say yes to that, if they refused the offer, in which case we can then get the details to see if that was a disqualifying circumstance or not. So they are supposed to self-report it, but they don't always do that. Because you are aware of who you've made offers to and who's refused those offers, you do have the ability to report that to us. And it is of a tremendous help to the division, to the agency. And then obviously, if that could be done as soon as possible, then we can follow up on that. We can put a hold on the benefits for the individual while we investigate whether or not the work was suitable. So New Mexico law allows us to, requires us to investigate it. But what we're looking in order to deem if it's suitable, and there are 3 elements that we're examining there. First of which, is there a bona fide offer? So not just a simple, it'd be nice if you would come work for me, not a bona fide offer. That there is a specific start date, specific job title, specific duties, specific pay rate, etc. So that's what we consider to be a bona fide offer. Next, is the work suitable? So is the individual qualified to perform that work? And then what we'll get information to see, is it comparable to something they've done in the past? Is it within a reasonable commuting distance from their home, etc. So that's part of the investigation. And then finally, what we look at are there compelling personal reasons that would allow them to decline or refuse the offer. So the only way we can go into that investigation is if we're aware of it, and we do rely heavily upon the employers to let us know that that has indeed occurred. Right, these next three areas, as it's labeled here, they're the highest impact areas, and this is where we're going to spend a big part of our time. So this is in responding to the unemployment insurance claims. There's paperwork that's sent out every time a claim is filed. You're having clear employee policies and then maintaining records, which you can then provide to us as part of our investigation to determine whether or not the individual is out of work due to no fault of their own. And then we'll go over some of the eligibility requirements so you have an understanding of what we're looking at and why a decision might be made in a certain way. And again, these three are going to be intertwined or intermingled and presented kind of as one concept. So as far as policies and procedures, what's ideal is if those policies and procedures can be geared toward your hiring and retaining the best employees, which is obviously something you want as well, but then also quickly separating employees who aren't working out for you, in that position, and then documenting any instances of misconduct, because that is, again, something crucial in our investigation. Then also, we would like for you to be timely in responding to any of our requests for information and be diligent to detail in all stages of the claim. For us, oftentimes, the more information, the better. We can sift through it, and find what we need if that's the case. So if you're questioning what needs to be provided, err on the side of providing too much versus too little. And then what we'll do finally is I'll go through the appeal process. So if a determination is made on a claim that we allow benefits to a claimant and you disagree with that determination, you do have the opportunity to file an appeal. So I'll go through that briefly at the end. All right, company policies and procedures. So you may have heard, and maybe not, but oftentimes a claim's outcome is determined before the individual even applies for benefits. So your policies and what happens day to day in your business, your personnel practices, oftentimes do determine your success in disputing an unemployment insurance claim. So some of the things that can be helpful for us in the investigations is if you have your employees on, here it says written notice of expectations. So kind of written goals, written, tasks or responsibilities. And one of the things that makes it easy is to use SMART goals, to establish goals that are specific, that are measurable, that are attainable, so something that is within the realm of possibility, that's relevant, so to the job that they're doing, and that they're time bound. So if it covers all of that, it's easy for us to see if the person is doing what they're supposed to be doing or not. The time bound, so is what gives deadlines. If there are certain tasks that need to be completed by the end of the year, certain reports that must be submitted. That's something that's black and white, that's easy for us to issue a determination on. Specific, is going through certain tasks. And we do see this in a lot of policies, but for those of you who might not have it, consider implementing this versus just you're telling us that, well, they weren't doing their job. Well, what weren't they doing? We do need the specifics in those circumstances. One of the other things that we do consider is if the policies are uniformly and fairly enforced across all similar groups of people. So say, for example, there's an attendance policy, that there is a person that was discharged because they were tardy and then they called in sick late. And that, according to the policy, is, a fireable offense. But then there are other, if the claimant can demonstrate to us, there are other people who far exceeded that and have maybe only gotten a verbal warning. Then if there's not equitable enforcement of the policy, again, that's something that could uh, kind of sway our decision toward allowing benefits here because it's not clear what the expectation is. Yes, there's a policy, but it's not necessarily followed. And then the last point here is avoid making emotional decisions. I know that you could get angry or you could be frustrated with one of your employees and perhaps fire them as a result. But if all your ducks aren't in a row, you obviously have the right to discharge them. But if that's simply the only reason why they were let go, is they probably then would receive benefits. We're going to go through the two main types of separations. So someone quitting or voluntarily leaving, or someone being fired or discharged. All right, so this is a section of the law that addresses quits. So an individual shall be disqualified for and shall not be eligible to receive benefits if it is determined by the division that the individual left employment voluntarily without good cause in connection with the employment. So that's what we're looking at when we're making a determination on a quit. So what is considered good cause connected with the work? So here's a court case. We are bound by case law. So this is something that had gone through, I don't know if this was the New Mexico State Supreme Court, but it established this definition, which is saying that good cause is established when an individual faces compelling and necessitous circumstances of such magnitude that there is no alternative to leaving gainful employment. So that's part of the guidance that we have. So some examples of that might be an individual who is being sexually harassed at work, someone who's being verbally abused at work, someone who's exposed to hazardous working conditions, say, for example, without any safety measures in place. If a claimant employee is repeatedly not being paid when payment to them is due, or another one would be an elimination of benefits. So, as of today, they have medical, dental, vision insurance, and then, as of the new year, those are gone. We do consider that good cause for quitting that particular job. And again, those are only examples. That is by no means an exhaustive list. So reasons that are not considered good cause connected with the work, and we see these and many more on a regular basis. So someone who leaves for personal or domestic reasons, that's not considered good cause. Leaving to care for sick relatives. There was an exception that allowed that during the pandemic, but that has long expired. So that's back to being not good cause connected with the work. Moving to accompany a spouse to a different geographic location. There is an exception for military spouses, and we'll talk about that in just a moment. Leaving work because they don't have childcare, leaving work to attend school full-time, or leaving work quitting due to a lack of transportation. Again, those are not considered to be good cause that would allow them to receive benefits if they quit under those circumstances. So in order for a claimant to establish good cause, the claimant has to show to us that they made reasonable efforts to preserve their employment. So it's their responsibility to try to resolve any of the problems or grievances that they had. So if there is a grievance policy or procedure, it is expected that they follow it. They have to notify management of their concerns. Obviously, how can something be addressed if management isn't aware of it? And then management also has to be given a reasonable amount of time to resolve the issue. Not that I, the claimant, reported it to you yesterday and I expect it to be miraculously fixed already today. So to give a reasonable amount of time to do whatever needs to be done. So those are all things that we would look at in making a quit determination. These are the two exceptions to the good cause rule. The first of which is the second bullet point here. Someone who has to relocate with a spouse who's on active military orders is allowed benefits. So these are specific exclusions in the law. And then the first one is if they have to quit due to domestic abuse. They do have to provide some sort of documentation to us, not necessarily to the employer, to us. Can be a police report, can be something from an attorney, from clergy, from, whatever, but just that there is some sort of documentation to say that this is what they've been experiencing or enduring and that they had to quit their job as a result of that. So in these cases, you, the employer, your account is not charged, but the benefits are just paid directly from the trust fund. So even though here we allow the benefits, there is no impact to you or your tax rate on these. Here, so as far as some best practices in terms of voluntary leaving or quitting. So if you provide a complaint process that employees can express their concerns with management, that obviously is in keeping with what we just talked about on the previous slide, require the employees to follow that complaint process, then promptly address any complaints and eliminate unreasonable conditions. So obviously to address any sort of harassment, whether it be racial discrimination, sexual harassment, whatever, address any unsafe working conditions, and then obviously adhere to wage and hour laws and timely and appropriately pay your employees. Then we also recommend that you investigate complaints that might not be valid, but then that is the result of your investigation. So it was reported, it was determined that it wasn't valid, then they obviously don't have the grounds to quit. We wouldn't consider it good cause because it was reported as it should have been, it was investigated as it should have been, but the conclusion was, that there is no discrimination or harassment taking place. Now to move on to firing or discharges. This is a section of the law that addresses that. So an individual shall be disqualified for and shall not be eligible to receive benefits if it is determined by the division that the individual has been discharged for misconduct connected with the individual's employment. And misconduct is the key word there. So what do we mean by misconduct? So we've defined it as any kind of willful or deliberate behavior which is harmful to the employer's legitimate business interests. So the employee has to know that the behavior could result in termination. In most cases, the conduct must occur on the job or at least on the employer's premises. So here again, we have some examples of misconduct, not an exhaustive list. So repeated absences or tardiness after being warned. So they know it's a problem, they know that their job's in jeopardy, considered misconduct. Willful violation of company policies without good cause or excuse. Insubordination, theft, dishonesty or falsification of records, such as timesheets, could also be on their initial job application. Fighting on the job, rudeness to customers after being warned, repeated cash shortages after being warned, and then being intoxicated on the job. And then what is not misconduct? So to contrast that. So mere inefficient or unsatisfactory job performance, the inability to perform to the employer's standards, and then any isolated instances of carelessness or ordinary negligence would not constitute misconduct. Second bullet point here, in order for poor job performance to be considered misconduct, the employer has to be able to show that the employee is capable of performing the job to the standards or expectations that they're being held to. So the most frequent way of providing that to us, demonstrating that it is, misconduct and that we could deny benefits for poor job performance, is showing that they previously were meeting those standards, and then all things remaining the same, they now aren't. So that's what we're looking for there. Because obviously, if they were meeting it, but then, some of the equipment is broken, that could explain the dip in their productivity, if there are extenuating circumstances. But if everything remains the same, they previously were meeting expectations, now aren't, we can determine that as misconduct. Here we're contrasting the two reasons, someone voluntarily leaving or quitting and someone being fired. It's critical because the type of separation determines who has the burden of proof. So who has to provide the evidence to us? Who has to prove their case in order for us to either allow or deny benefits? With a discharge, because the employer is the moving party, they have the burden of proof to show misconduct. And then on the opposite side of that, when a claimant voluntarily quits their job, is the claimant who has the burden of proof of showing that they had good cause connected with the employment to leave. Then this is another case here in New Mexico that was actually against this agency back in 1996. Where it says, and I'll just read the quote there, among the most important considerations in resolving whether an employee quit or was fired is an examination of the subjective intentions and understandings of that employee. So this is where we get the moving party. So it could be someone resigns, but they were told, if you don't quit, I'm going to fire you. We don't consider the claimant to be the moving party in that scenario. They only resigned because they were being forced to resign. So we would actually address that as a discharge. So we're kind of looking at who set this separation in motion. Here, as far as best practices in terms of firing employees, again, avoid emotional decisions. Know the difference between misconduct and poor performance. Again, you have the right to separate with any of the employees, but as far as what we're held to the law, we have to prove misconduct or show misconduct in order to deny benefits. So just to reiterate some of the things that we've covered, so poor performance alone is not grounds for denial of benefit. It's not considered misconduct. In evaluating and disciplining employees, employers should focus on the performance of specific quantifiable duties and tasks. So that goes back to the SMART goals. If an employee is on notice that a particular behavior violates the employer's interests and they continue to engage in that behavior, then misconduct can be established. So it's something they've been made aware of is a problem and they continue to do it, that is considered misconduct. And then potential misconduct, an employee's failure to meet any objective productivity measures after a warning, failure to be at a workstation after a warning, repeating the same mistake after a warning. And again, it says potential because there could be extenuating circumstances to any one of those, which would be part of our investigation. So we would review that prior to making a determination. Now, as far as the appeals, so as I said, if there is a decision in which you are adversely affected, so on a separation, if we allow benefits, then you, the employer, is considered the aggrieved party, so to speak, and then you do have the right to file an appeal. So when the claimant files their claim, that separation issue and any other issue related to their being able to work, etc., go through an adjudication process. We have our guidelines are to make determinations on those within 21 days. It can go longer depending on the amount of information we need, the cooperation we're getting from both parties, etc. But the employer has 10 days to respond to the initial filing of the claim. So if I were to file a claim today, paperwork goes out to you tomorrow. It's available on your account, immediately, but it goes out in the mail tomorrow, and then it's 10 days from the date on that letter. So we need that response within 10 days. It's then reviewed by one of our adjudicators. They reach out to either you or the claimant if they need additional information, if any witnesses are provided, etc. We can talk to them as well. Then we make a decision and a determination is issued. The notice goes out and then the aggrieved party has the right to file an appeal. So if we allow benefits, you have the right to file an appeal. The administrative hearing is held. That's done telephonically. Decision is made. If you still disagree with the decision, then you can appeal to higher authority, and I'll talk to you just a little bit about what that is. That has to be done within 15 days of the appeal tribunal decision. And then the higher authority issues their decision. And then if you still disagree with it, then the next step is to go outside of our agency to district court. And then that has to be filed within 30 days of the decision from higher authority. So what's the difference between the two levels, lower authority and higher authority? So our appeal tribunal is a lower authority. So that's the first level of appeal, and an actual appeal hearing is conducted. So where both you and the claimant have the opportunity to participate, testify, etc. You're welcome to bring witnesses, submit documentation, etc. If a decision goes to higher authority, that's the secretary of our agency or the board of review. And that second level of appeal, there isn't actually a hearing. They review the record from the lower level hearing. So there is a transcript of the hearing. They have the evidence or documentation that was submitted at that time, and they simply review it and then either affirm the previous decision or reverse it. Just to let you know a little bit more about the hearing itself, it is another opportunity for you to present your case. Ideally, you've done that up front, provided all the documentation that you've had to us, that we can make the appropriate decision at the adjudication level, that it's not necessary to go to the next step. It is an informal legal proceeding, and again, both you and the claimant would be part of the hearing, and again, witnesses can be called as well. It's presided over by an administrative law judge who is an employee of this agency. All testimony is given under oath. Any evidence, documentation can be presented and should be presented if you have, whatever you may have to support your case. Each side does have the opportunity to cross-examine the other side, so to ask questions, which is good in that a record is created. And again, that's what would be reviewed at the next step if it is appealed further. And then this section of the New Mexico Annotated Code is where the requirements for an appeal hearing are all laid out. Again, it is telephonic, so all parties to an appeal have to contact the appeal tribunal no later than 4 p.m. on the business date prior to the scheduled hearing date. Can be done immediately as soon as you get the notice, but no later than 4 p.m. If you don't confirm your participation by 4 p.m. on the prior day, then the hearing or the appeal will be dismissed. And as I just said, right, you can call in anytime after receiving the notice. It's not that you have to wait for the day prior. All right. So that's the information I have. And for the remainder of the time, Charles will respond to any questions that you might have. Thank you so much.
Thank you, Steve. So Charles, our first question is, what is the lowest possible unemployment tax rate?
So the lowest rate is 0.33% right now, and that's the lowest you can go as far as rates affecting your tax rate.
This question is, how do you report an offer has been made?
So in your employer account, there is an actual link. It says refusal of suitable work when you log in. You just click on it, and it will actually allow you to generate and answer a questionnaire, giving us the details, so we can then reach out to the claimant and investigate it.
Could a job description that is signed by the employee be considered written notice or expectations?
It would be considered expectations as far as written notice, as far as talking about warnings. we would not consider that. That would be something that would have to come after the employee's been there and has not met the expectations.
Does your online portal allow us to see who is currently collecting unemployment from our company?
Um, you can go in and see the correspondence in your online portal. There, it will give you the determination notices, and that's how you can tell who is receiving benefits from your company.
Would us requiring them to work their shift and them not being able to, for childcare reasons, be an issue? Are we required to work around their schedule?
Um, you're not required to work around the schedule. Basically, that's on the burden of the employee. They have to try and figure out a way and make arrangements for that. So that would be more of an attendance issue. So, you can work with them, that's great, but it's still their responsibility to make the arrangements.
If an employee has been laid off, I was told there was no need to reply to UI questionnaire claim, for their decision will be in favor of the claimant. Is this correct?
If there is not a response on the layoff, we do automatically approve them, but um, in cases that may delay it a little bit if there's not a response. So if you can go in there and respond, and that does help out the employee. And then also, um, if something happens and there's something that you may put in there that may have been a little bit something misconduct, we would investigate it a little further. So, but yeah, of course, you don't have to respond if it's a layoff and you're fine with them getting the benefits.
But we do prefer you to look at your correspondence and, of course,
Yes,
reply. Thank you.
yes.
Next question is attendance issues being late to work considered misconduct or poor performance if it is written in a written company policy?
That would be considered a misconduct. So any attendance issues, late for work, so any tardy, missing work, would all be misconduct. And just make sure you document all those instances and warnings. And that way, when we get that information, we can adjudicate the claim.
What about probationary periods and standards? What if the employee does not hit the standard during any of those first 3 months? Is that grounds for benefits?
Yes, if they are a probationary employee and they were not able to meet the expectations, that is grounds for them to receive benefits.
What happens if you get locked out of your account and it's been a week? Can you give limited access to an employer account?
That you would have to actually reach out to the tax department so they can unlock your claim for you or your account. And you can either do that on by logging into your account and there's an access there for a chat, or you can go call the call center and they can assist you with that.
How long do ex-employees get to collect unemployment?
So the maximum they can collect is 26 weeks per claim. So it's not necessarily, not all of them get the 26 weeks, but that is the maximum benefit amount.
We are a Texas-based company and our employees work in Texas. If we have an employee with a New Mexico address, are they reported for New Mexico or Texas unemployment?
Um, could you repeat that one more time,
It's
please?
asking if they are based in Texas and the work is done in Texas, but the employee lives in New Mexico, where would they have to file for benefits, or where do they report?
The wages would be reported in a state where a majority of the work is performed. So majority means like 6 months or more.
For that one, I think what they're saying specifically, if you're in Texas, they're traveling from New Mexico to Texas, you would actually be filing everything in Texas. Even though they live here, they're crossing over to Texas to do the work.
Oh,
So it's where the work is done, which is what you just said, Charles. I just wanted to reiterate what you just said.
yes. So it would be where the work is performed.
Mhm. How long is an employer's tax rate affected after an employee is found deserving of unemployment?
Um, Sorry, bear with me one moment.
And while Charles is looking for that, I just wanted to remind everyone again that this is being recorded. It will be on our YouTube channel. I will also send you a direct email as well tomorrow with the direct link to this video as well, so you can reference it at any time. So again, Charles, how often are tax rates reviewed? Is it every year?
Yes, tax rates are reviewed every year.
Okay, so we have a little bit of an opposite question. If I have employees who live in Texas but work here in New Mexico, do I have to pay Texas unemployment tax?
The wages would be reported in the state where majority of the work is being performed. So if they live, if they're performing the work in New Mexico, that's where you would report the wages.
What if a requirement of employment is to obtain a property and casualty license and the employee is not able to pass the license test, therefore they cannot obtain the required license? If we let them go, would they be allowed to get benefits?
No, as long as if they made the attempts for that and they were not able to do that, if there was no other work for them to perform, then they would not be eligible for benefits.
The New Mexico state tax rate calculation seems to be a bit more complex than other state agencies since it uses both the reserve ratio method and benefit ratio components. Can you explain why New Mexico took their approach on the calculation method? And I will just address that a little bit before you do, Charles. There was specific legislation that went into place several years back for this specific calculation that was adopted through the New Mexico legislature and put into law. So that's why the calculation is how it is until there is another law that would change that approach to the calculation method. Is there anything you wanted to add to that, Charles?
No, got that pretty good.
Okay. And if you ever want to talk about that calculation method, you're more than welcome to reach out to our unemployment insurance tax unit. I will put here in the chat our phone number as well as an email that you can reach them at. The next question, Charles, is how long is an employer's tax rate effective after? Oh, we just read that one. So sorry. Next question. Does your agency use third-party software to track payroll data when a claimant files to ensure the wages were reported to the correct state?
So the reporting of the wages is basically a responsibility of the employer. So the only thing we do is what Steve was talking about earlier, the new hire cross match, to see if someone is currently working.
Does an employer have the rights to fire an employee without any type of verbal and or written warning, i.e., a comment made being taken as sexual harassment?
So you have the right to fire your employee at any time. As far as whether or not they'll receive benefits, you have to make sure that you're following your policies and procedures. And if it does require warnings and letting them know their job is in jeopardy, and they have to have the understanding of the policy and rule that they broke. So misconduct has to be established, and they have to be aware of that.
How can I request a tax rate review? And again, I think that's just contacting the UI tax unit, and I put the two contact methods in the chat. So that would be calling our 1877 phone number, and that's Monday through Friday, 8 a.m. to 4:30 p.m., or by email at uitax.support@dws.nm.gov. Um, are these same guidelines for nonprofit businesses as well, with less than 10 employees?
As far as what they, if they're eligible for unemployment, so nonprofit organizations typically don't pay into the unemployment insurance tax, and as employers are not considered bona fide employment, so we would not use that as far as making them eligible or denying them benefits.
We could just have another clarification for working in Texas or in New Mexico. And again, it's where the majority of the work is done, is where the taxes are paid. So if the majority of the work, if your employee lives in New Mexico, but the work is being done in Texas, and they travel over to Texas to do that work, you would be paying those taxes in Texas. And just opposite, if your employees live in Colorado, Arizona, Texas, and they're coming into New Mexico to do that work, and your company is based here in New Mexico, you would pay in New Mexico. Is that correct, Charles?
Yes, that is correct.
Should there be a job description, job duties for every employee in order to prove, if later fired, the lack of job performance?
There would have to be some documentation and an understanding of what their job duties are, and that way, when we go to investigate it, we can see if they did in fact meet those requirements, or if they were not able to perform the job duties. And without that description, then there's not a way for us to really deny the claimant if we don't have any, if they were never told what their true job duties are.
We have a few questions here around policy. So, how many warnings are required to fire an employee? What if they are breaking more than one policy? And then also, are warnings required for aggressive, threatening behaviors toward another staff person? Before you jump in, Charles, I just wanted to emphasize that we do have a labor relations division here at the Department of Workforce Solutions that oversees labor law, discrimination, wage and hour. So if you have any questions regarding that, I would recommend reaching out to them. And I will also include that in the email that goes out to you as well. And I will put their phone number into the chat. But those, Charles, can you just address the type of documentation that it's nice to have from an employer when we are doing a determination of benefits?
So the best thing for you guys to send to us would be, the policy, of course, that you have, any written warnings, documented verbal warnings. If it's not documented, then, we can't really use that. So as far as, the number of warnings you give, they have to be aware that their job is in jeopardy, have time to, fix the situation or correct their behaviors. But if we can get that information and any other evidence or witness statements that you have, and a way to contact the witnesses, that would greatly help you when pleading your case for the employers that you let go.
How long should employers keep documentation after DWS makes a decision on unemployment?
Um, as soon as we make the decision, if you're going to go through the appeal process, you'd want to keep it just long enough, to go through that. Um, you know, most companies have their own standards of how long they're going to keep their own records, but just long as you keep it long enough to go through any of the processes that you may want to pursue if it's not in your favor.
Are there any NMDWS regulations that New Mexico tribal employers are exempt from?
No, all employers are held to the same standards when it comes to the decision of unemployment benefits to employees.
Is there a certain number of warnings that need to be met before you can let someone go?
Yeah, there has to be enough warnings to give them the warning, allow them time to approve, and then continue. And as long as it's documented, it can't be just like, okay, you have one warning and we're letting you go. there are a few cases where there are circumstances that is not true. Like if there's theft, obviously you don't need to warn someone for theft. But other than that, I would say, 2 to 3 warnings. If we see that, it's a good case to deny the claimant benefits.
Clarify for nonprofits, if they terminate an employee and the employee gets unemployment, is the rate of the nonprofit impacted?
It should not be because we would not be using a nonprofit employer as the reason for the benefits being allowed. We would usually not even work on that one because, again, the nonprofit, as far as the state of New Mexico, it's not bona fide employment because you do not pay into the tax.
Okay, so for clarification, nonprofits do not have to pay unemployment insurance tax?
Correct.
Okay. What if an employee has several attendance days documented on a write-up and the next write-up was the same?
So if they had several, and then they missed again, that want to document it. But if there's no additional days missed and it's the same thing, that would not constitute us a good reason to disqualify them. If we get a lot of warnings where it's just, okay, here's a warning, it has everything listed. Then there's another warning and it has them all listed again, but another incident, that is fine.
You mentioned 2 to 3 warnings would be sufficient, but in what time frame? 6 months or a year time frame? Is there a specific time frame?
If it's within a year, that's fine. If you warn someone like 2 years ago and you let the behavior continue and then you want to let them go, we would consider that condoned behavior. So if multiple warnings within a year is what we would consider.
Does it depend on the type of nonprofit, 501(c)(3) or 501(c)(5)?
The pretty that one I am not too sure on. We'll have to, Stacy, if you want to see if we can get back to them on that.
Yeah, of course we will. And just again, reach out to us from the tax unit and they can answer those questions for you as well, but definitely probably the 501(c)(3s. The one that we would look into is the 501(c)(5). So I do have your name flagged for the individual that did that question, and we will get back to you specifically. Is there anything else, Charles, that you tend to see that you want to address as a common question that you might receive?
Yeah, I mean, the biggest thing that we get when my team is adjudicating, my staff always is getting questions, what do I need to provide? And that is the biggest thing to help you spur your tax rate from going up is those key things. Make sure you document everything. You have a policy in place. Make sure the employer signs an acknowledgement that they understand the policy. And warnings. A lot of people we talk to them, we give them a verbal, but there's no documentation. Document all verbal warnings, and that's the key thing. The more documentation we have, the better it's going to go for you as the moving party separating from the employment. And then also what Steve had talked about, that refusal of suitable work. You guys offer them work, even if you're eliminating a position, but you offer them something else and they don't take it, make sure you're filling that out. That'll help you out in the long run as well.
Which wages specifically are reported quarterly? Are they gross or subject wages?
Gross wages.
Thank you. Does the employee need to sign the documentation of the verbal warning?
No. As we know, a lot of employees will refuse to sign it. As long as it's documented and the employer refused to sign, that's fine.
Okay. If we communicate through text messages via a stored cell phone, does that count as specific documentation, or does it need to be written out via an email or something more formal?
It would need to be more formal because when it comes to evidence of the text messages, it's really hard for us to determine who they were sent to, who received it, or even if they can also say, I never received it. So that's more formal documentation would benefit you in the long run.
So again, we had another question regarding nonprofits. I would recommend if you are currently in nonprofits that's wondering about your tax rate and how that works for your specific company, I would highly recommend reaching out to our unemployment insurance tax unit by phone or by email and ask for a review of your account if you are wondering specifically for you, and just ensure that everything looks okay and that all your questions are answered for specifically nonprofits, but that's open to any employer that can do that. In the case asking employees to send an email, is that a better form of communication? Is a better form of communication not arriving to work as scheduled for documentation? Oh,
Uh,
should they be emailing them?
yeah, an email would be a better documentation. But even if the in documentation we have, I mean, we'll take if you have it documented, they miss these days, and that's on the warning, that's plenty of documentation for us. But if you can get an email from them that is, and you can provide that as evidence, we can use that a lot better than we can use a text message.
Do text messages from an employee saying that they quit serve as documentation of resignation?
Um, we would really prefer you to get an actual resignation letter. If they submit a text message and we have that, of course, we're going to investigate it and we'll ask the former employee to confirm that they did do that. But again, if they say they didn't and that wasn't them, if you don't have that formal resignation letter, then it's going to be on the benefit burden of proof would be on you that they did quit at that time.
What if subject wages are on the claim form instead of gross, which were reported by a TPA?
That you would have to reach out to our tax unit to get that corrected.
Okay, and then we did have another question regarding access of this recording, and yes, it will be available on YouTube. You do not have to be a subscriber to access those videos. They are open to you at any time, and that will be up on our YouTube channel tomorrow. And we will send you a direct email with a direct link to this presentation so you can access that right away. Anything else? Ending thoughts, Charles, as we wrap up today?
Uh, no, I mean, I said, I just want to again tell you guys the documentation is the key thing for you. And, my team's always willing to reach out. We reach out all the time. So just make sure you complete those questionnaires we send you right away. And when we reach out to you for additional information, please get back to us as soon as possible so we can help you out with that.
Perfect. Thank you all so much for your attendance. We really appreciate the great questions that you had today. If we weren't able to get to your questions specifically, we will be looking through this, and I would recommend going to our FAQs on our Department of Workforce Solutions website where you can get more answers to those questions. And as I've mentioned a few times, just reaching out to us through our phone number, 1-877-664-6984, or by email, which is at uitax.support@dws.nm.gov. Thank you all so much, and I hope you all have a great afternoon. Bye. Thank you.